Well, a victory for opponents of the NDAA. A federal judge has ruled that provisions in the controversial law may violate our constitutional rights. President Obama signed the National Defense Authorization Act back in December. The move has outraged activists that say the law is so vague it allows U.S. citizens to indefinitely be detained by the military without due process. But a group of activists sued President Obama, and yesterday the federal judge took their side. Here's part of the court order issued by Judge Catherine Forrest. It reads, quote, "This court is acutely aware that preliminarily enjoining an act of Congress must be done with great caution. However, it is the responsibility of our judicial system to protect the public from acts of which Congress infringe upon constitutional rights." So the law has been blocked, at least for now. And just hours ago, an amendment to the NDAA was presented on the House floor. Representative Andrew Smith led the fight to bar indefinite detention for terror suspects on U.S. soil. A vote on the amendment is expected to happen tomorrow. To talk more about the case and the implications of it, I'm joined now by Alexa O'Brien, a journalist for WL Central and founder of U.S. Day of Rage. Welcome to the show, Alexa. So a huge victory for you. Your reaction to the judge's ruling?
Well, I'm very pleased with the judge's ruling, I thought her ruling, the 68-page ruling that she wrote, was very well thought out and very well reasoned. It's only the beginning.
And so, Alexa, you are one of 7 plaintiffs in this case. Explain to us your testimony, the case you made to the judge that you had standing to sue because you feared you could be detained under the NDAA.
Yes, absolutely. That is one of the clear rulings that Judge Forrest made, was that the plaintiffs, myself included, had standing to bring case against the U.S. government. I had a fairly lengthy affidavit and lengthy deposition. My deposition took 2 days. Of course, I also testified in court. So some of the features of that was the targeting by private security contractors working in conjunction with the U.S. government to target me. 2 of those firms, one came out in the WikiLeaks release of the global intelligence files related to the private security intelligence firm Stratford. In one of those emails, a exchange between a gentleman named Thomas Kopecki, who is the director of operations at Fortis Investigative Research, and Fortis Protective Services, in an exchange with Fred Burton, who is the head of counterterrorism at Stratford and who was also the former deputy chief of the Department of State's counterterrorism division for the diplomatic security services, had been specifically tasked to tie an organization that I helped found, whose only avowed purpose is campaign finance reform, to Islamic fundamentalists and Saudi jihadists. And there's more. That's just one part of it. I have had a federal agent tell me that they've seen DHS documents detailing the types of surveillance for U.S. Day of Rage. The director of federal programs at my former employment informed me in a business meeting that people in the government had been asking about me by name. Therefore, because I cover Guantanamo and have spoken to individuals that the U.S. government, spoken to or about individuals that the U.S. government considers terrorists, I definitely had, it had a chilling effect on my freedom of speech.
And so these are all arguments that you made to the judge, and apparently the judge sided with you. And what makes the NDAA so controversial is how vague it is. And its vagueness, critics say, and plaintiffs, as yourself, say it's all open to all kinds of scary possibilities. The plaintiffs fear that even reporting on terrorist suspects could be considered grounds for being detained under this law. As you said, a lot of the work that you do, that you could become under scrutiny and be subject to indefinite detainment. And the judge acknowledged some of the danger of the vague language in this bill. Can you talk about that?
Yeah, well, I mean, you use the subjunctive tense. You said could. I mean, I was, already. So, that was already happening. I was already being targeted. Further, if you look at the war on terror and how it's fought fought through intelligence. And right now, I would say that there is a battle over the information sharing environment. The actions of a journalist collecting information to write a story, to do investigative work, are not very different in terms of transferable skills than the actions of an intelligence collector, so to speak. And so there is really clearly a conflict, a competition between the intelligence sector of society and the press. And up until this particular ruling, it looked like the press was losing. I mean, I'm very pleased with this ruling. Of course, this is only the beginning. I mean, the council has spoken out publicly in their discussions with the press that they are, calling on President Obama to, essentially permanently put an injunction on this particular type of statute.
Now, this is just the beginning. It's a preliminary injunction. That's what's in place. And this measure is only temporary. So are you confident that it will continue to work in your favor and ultimately that you'll prevail?
Whether I prevail or not is sort of a moot point in a certain sense. I mean, I want to prevail. I can't tell the future. I am naturally taking it one step at a time. I mean, an Australian friend of mine was joking with me over Twitter yesterday. They said, you've basically pushed it back to 2011. I mean, we have to really, and I'm speaking in my own person now, I'm not speaking for the other plaintiffs, but we have to look at the indefinite detention of prisoners of war, too, in this country. I mean, I think that there's a lot of work to be done in the United States to reestablish the rule of law and the principles of our democratic republic.
Now, Alexa, an amendment to the NDAA was presented on the House floor just moments ago to get rid of the provision that allows for indefinite detention on U.S. soil. What do you make of the timing? It's just one day after this ruling.
Well, I'm not going to place speculation here. This is what I know. I haven't read the statute itself. Whether or not we rule out indefinite detention, the question is who is the terror suspect? I mean, in the case of the National Defense Authorization Act, which we brought suit towards the U.S. government for, the language of substantially support, associated forces. I mean, what are those things? So, being called a terror suspect by the U.S. government is not a clear diagnosis. We need to understand what exactly is the U.S. government saying is a criminal act, right? Firstly. And secondly, I looked at the Human Rights First organization sort of, I guess they proposed this as a great idea. But, I don't have a lot of trust in Human Rights First when Harold Coe, I was on their board of directors. This is a gentleman who is a proponent for drone warfare. I don't know how you connect human rights and drone warfare together. So that's my just preliminary opinion.
All right, Alexa, thank you for coming on the show. It'll be very interesting to see how this plays out. Again, the vote to that amendment on the House floor is expected tomorrow, and we, of course, will be keeping a close eye on the developments on this case. Alexa, thanks for coming on the show. That was Alexa O'Brien, a journalist for WL Central and founder of U.S. Day of Rage.